Hello everyone. In this session, we are going to have a discussion on intellectual property rights. Now, speaking from the point of view of your examination, in the prelims examination, we don't expect much questions to come from here. And even if they come, we'll discuss how exactly questions can come. But in the mains examination, this is one topic that has a good significance. So we'll try to understand various aspects of it. So what our module is going to cover here is, first of all, what is the meaning of intellectual property, the different types of intellectual properties, and then after that we'll try to understand what is the need for having an IPR, what is the need for having an IPR or intellectual property rights, then what are the different kinds of intellectual properties that are being provided, the national IPR policy of India, and then finally we'll have a discussion on traditional knowledge database library. So these are the important things that we have to discuss, especially from the point of view of national IPR policy of 2016. We need to understand what was the requirement, what are the highlights, and what are the advantages that people of India would have with this particular policy coming into picture. So these are the few things that we need to understand here. But to start with, first of all, we need to understand what exactly do we mean by intellectual property. So as the name itself suggests, you are talking about intellectual property. So what is intellectual? Intellectual is something that is coming out of the mind of a person, intellect of a person. That's why you will call it as intellectual, right? So if there is a property that can be associated with creation of the mind, right? So for example, an invention, a book that you have written, even a small logo that you have created, each and everything is something that is creation of the mind. So that's why these are the things that come under intellectual property. So anything that I have created on myself would be my intellectual property, right? So in this way, you can say that there are many ways in which we can divide the different kinds of properties that can be classified as creation of the mind. So anything like that can be classified into different kinds of intellectual properties. So what does the definition say? Refers to creation of the mind such as inventions, literary and artistic work, designs, symbols, names and images used in commerce. So anything that is being used for commercial purpose, or anything where you want to associate your name with it, you will call it as intellectual property. Now, when we talk about intellectual property, as I discussed, there can be many examples of intellectual properties, and we divide them into different kinds. So for example, as I said, that inventions can be said to be intellectual property. Even logos you create can be called as intellectual property. The vaccines can come under intellectual property. So all these are the things that can be classified into intellectual property in one way or the other. So this is what we have to understand going forward. Now, before going to the different kinds of intellectual properties that we have, we also need to understand what is the need. What is the need for protection of intellectual property? Now, a simple way of thinking about this would be that, okay, if intellectual property rights have been granted to somebody, then maybe they get commercial benefit out of it. Maybe they get some advantages out of it. But you have to think not only from the perspective of the creator, but you also have to understand this from the perspective of the consumer. Yes, creator will definitely have a lot of benefit out of declaring something as intellectual property rights, but at the same time, because of presence of intellectual property rights, the consumers will also be benefited. So that's why, let's say this is a mains based question. If a question comes in the mains examination, what is the need for protection of intellectual property? Why do we need to have IPRs? Then in that case, you don't just have to focus on what the creators will have benefit out of it, but also you have to understand from the consumer's perspective. So let's try to understand both the perspective first, so that you get a holistic view of why IPRs are required. So as I said, that this can actually be a mains question, that what is the need for protection of intellectual property rights, what is the need for protection of intellectual property, or what is the need for having intellectual property rights. So these are the two ways in which questions can be asked in your examination. So let's try to understand it first from creator's perspective. So what do you see here? First point is capacity to create and invent. So what we understand from this point is that if the creator has been enabled to invent more, to write more, to do more, in that case there are possibilities that a large variety of products and services will come into the market. Some which will be very, very helpful for the societal development as well. So, for example, take vaccines today. That we know that COVID vaccines came within a year. Why? Because there was strong support that was being provided by governments all over the world, and their rights were being protected. All the pharmaceutical companies who were working on building of vaccines, their rights were being protected. And that became a very important reason why they were interested in making vaccines. And they knew that they are going to do a lot for the society. Not a lot is being gained. For example, if you see, it's not that the vaccine companies today are gaining a lot. This was one of the fears when the vaccine development had started, that maybe vaccine companies will start charging exorbitant rates. But that didn't happen. We didn't see that happening. They all kept it low, and they also understand that this is a pandemic situation. So capacity to create and invent increases for the creator. They have more incentives to create more. They know that their rights will be protected. They know that there can be economic benefits out of it, right? So because of that, we need to understand that capacity to create and invent increases. Then protection encourages further innovation. My rights are being protected. I know that something that I am creating today is not going to be replicated elsewhere without my knowledge, without my approval, without my authorization. So that also is a big incentive for me. Otherwise, what will happen? That I create today I create something, tomorrow somebody just replicated it. I can't do anything about it. I would be, I probably will be devastated because of this, that nobody knows that this was my creation. I am not getting any benefit out of it. I'm not even able to tell people that I was the original inventor. So ultimately, I would be the one who would be discouraged to do something further. So this can happen, but if my rights are protected, if I am provided with intellectual property, there are higher chances that I would be ready to innovate further. I would be ready to do much more than what I have been able to do. And because I am being given a push, I am being lauded for my work, my inventions, my creations. This will push me further to do more, to invent more. Right? So this is again a very important point. More research and development can happen, more money will be pushed in, more infrastructure development can happen, and a wider variety of products and services can be developed. So that's why this will be a major push. And the last point, a very important point although, is acknowledgement. That I'm getting acknowledged for my work, I am being recognized for my work. Maybe I'm not getting a lot of money out of it, but I'm getting a lot of recognition because of this. And that also is a big push for many. And it's actually a very, very important factor. If you look at the things from psychological perspective, you'll understand that this is something people look for. So acknowledgement of the work, the good work that has been done by an organization and individual also goes a long way in making sure that more innovation can happen, better products and services can come out. So this is also a very important factor from creators perspective. Now let's move on to the consumer's perspective. How does a consumer benefit out of intellectual property rights? First, there will be economic growth. Developments, innovations will keep on happening. This will lead to more money being pushed into the market, and that ultimately can lead to economic growth. So sector wise growth can happen, overall growth can happen, individual level the growth would happen. So we know that it would give a push to anyone who is doing good, and that's why there will be economic benefits for the entire country also coming out of it. Then better and more efficient products, right? Let's just take a simple example of a mobile phone. Think about the mobile phones of early 2000s. Nokia 3310, 3315, and all those mobile phones that have become stock memes today because of their sturdiness. If you remember those phones, what could you do with that phone? You could talk, later you could send an SMS. When the mobile phones came into the market for the first time in India, the mobile rates were so high that incoming calls would be charged at perhaps I think 5 rupees per minute. Outgoing calls were 10 rupees per minute. Would you buy any plan today with 5 rupees per minute and 10 rupees per minute cost charges? You would not. There was no internet. You could not think of any social media, anything at all, right? It was just phone and just SMS. But huge innovation. Why? Because you could carry the phone in your pocket. and you could carry it out. So that was a big innovation. But after that, just look at what has happened with mobile phones since 2000s. And if you come to 2020, 21, etc., what do you see here? That now perhaps you don't even realize that, okay, primary role of a mobile phone is to talk on the phone. We don't even realize this because we are using extensive internet. You probably are using for entertainment purpose, we are using for gaming, we are doing xyz number of things. We can even, I mean, if there was a possibility, I could have even shot this video on my phone today. So look at where the mobile phones have gone because of the innovations that have happened on the phone. And how has that been made possible? Because of intellectual property rights. Because the companies that were producing mobile phones in the early days, they were provided a lot of push. They knew that this is something that will give them a lot of benefits, market wise also, market value wise also. And also they know that this is a big thing that they are doing, a great innovation that they are doing. And that's why there was a push that was provided. And ultimately, who is the beneficiary? The consumer. The consumer also is getting a benefit out of it. So that's why better and more efficient products will start to come out. The reliability of the products will increase, right? So, and this again goes to a lot of products today, that the reliability of the product has increased a lot as compared to what you used to see. And you go to any part of the product, especially if you look at consumer electronics, you will see that there has been a huge change that has happened in the entire sector. And then more publications, music and films. Even from that perspective, if authors copyrights are being protected, if somebody who's directing a movie, creating storylines are being protected, for them also it's a big thing, that they know that they will be recognized, their work will be recognized. And because their work is being recognized, they will start to push themselves more towards creating something which the consumer likes. So for example, if you look at the movies that are coming, you would see that there has been a lot of change in the Indian market as well in the last few years as compared to what we used to see. Why? Because the consumer behavior changed. The consumer was looking for something. The consumers demanding something. The rights of the creators being protected also pushes the creators to go forward to do more for the consumers. And at the end of the day, the consumers are benefiting out of that as well. If the author's rights were not protected, then in that case they are not getting any benefit out of it, they're not getting any recognition out of it. Let's say I publish a book, I write a book, but it goes in the name of somebody else. So what is the benefit that I'm getting out of it? I'm not getting anything. There is no recognition, there is no money, there is nothing. No economic value, no moral value, no societal value. So probably I'll not want to create. And then in that case, if I was writing good stories, then in that case, these good stories will never see the light of the day. And ultimately, the consumers will not be getting the products or the kinds of books that they were looking for. So that's why consumers also get a lot. So that's why when we talk about the need for protection of intellectual property rights, the rights of the creators and the benefits for the consumers both have to be taken into account. Now, let's move to different kinds of IPR. We'll try to understand what are the different kinds of IPR and understand some of the nuances associated with them. First of all, what are the different kinds? We have patents, we have trademarks, we have copyrights, we have trade secrets, we have industrial design right, and then the last one is geographical indication. These are the 6 kinds of IPRs. So let's have a look at all the IPRs one by one. First, we have patent. Now let's try to understand what is the meaning of a patent. Patent, as you can see the definition, refers to a set of rights granted by a sovereign state exclusively to an inventor for a limited period of time in exchange for detailed public disclosure of an invention. So patent is basically associated with an invention. So if there is a new creation, if there is something that has been invented, it could be a new product, it could be a new way of doing something, it could be a new technology. So all these kind of things will come under patents. Now, what do we mean by a patent? So patent is when you have a new way of doing something, a new technology, a new process for that technology implementation. All this will come under patents. So patent will basically look after the rights that you have for an invention that you have done or for a new process that you have invented. So it could be a new product or it could be a new process. For both, you get patents. So it refers to a set of rights granted by a sovereign state exclusively to an inventor for a limited period of time in exchange for detailed public disclosure of an invention. So that's why you have to understand that patents are provided for inventions. Patents are provided for inventions. It could be, as I said, a new product, a new technology, a new process. All these will come under patents. Now, talking about patents, first thing, if you want to get something patented, you have to submit or you have to make a detailed public disclosure of this is what the product is or this is what the process is. This becomes very essential for getting a patent granted. Now, one more thing, a couple of questions might come to your mind. First of all, who grants these patents? And are patents applicable everywhere? So, if you have to understand, first of all, the legal system of any country will protect the patents. That is something that you need to understand. Apart from that, when we talk about patents, so for example, if I have applied for a patent in India, then that patent holds only in India. That patent does not hold in the USA or Germany or XYZ nations. Alright, so these are territorial rights, you can say. Why territorial rights? Because these are being provided by a sovereign state, by a country, and this is going to be applicable only in that country, and that too for a limited period of time. It will be applicable, most of the cases we have seen that patents are applicable for 20 years. So it will be applicable for a fixed period of time against a detailed public disclosure of the information, and it will only be applicable in the country where you have applied for it. So for example, if I have patent for something in India, it doesn't mean that I have patent in USA also. I have to go to USA, apply for a patent there and get that patent. So this is how patents work. So these are few things that you need to understand. First, provided for an invention. Second, territorial rights only applicable in the country where you've applied for, and at the same time it is applicable only for a fixed tenure of time. Most of the times we have seen that this tenure is approximately 20 years. So used for protection of new inventions, ideas or processes, patent holders are required to pay a definite fee periodically to the government for the renewal of the patent. So as I said that it will be applicable only for a certain period of time, and if you want to renew it further, then you have to pay a fee for that to that particular government. All patents that are approved by the governments are for a limited period of time. As we discussed this, in principle, the patent owner has exclusive right to prevent or stop from being commercially exploiting the patented invention. Now this becomes very, very crucial that I get patent for something because I also want benefits out of it. I may get a lot of benefit out of it. It could be commercial, it could be non-commercial, but I get benefit out of it. Now let's say if I did not have rights to this kind of an invention, what can happen tomorrow is that somebody else will start using the same product, same process in their name, and they might exploit commercial values out of it. So I was the initial inventor, I did not get anything out of it, but somebody who copied this process or copied this product is able to get commercial benefit out of it. So that also has to be stopped. To prevent that also, patents become very, very important. For example, we have seen many of the traditional Indian medicines or processes being patented in the USA. We did not get it patented. Anyone from India did not get it patented, but it got patented in the USA by somebody. It could be a company, it could be an individual, but it got patented in the USA. It did not get patented in India. Just that because nobody filed for a patent in USA, we did not bother to do that. Something as simple as turmeric, something as simple as cow urine. These are things that have been patented in the USA. And we know that here, for one reason or the other, we have been using these kind of things. This is how patents can be exploited if somebody has not filed for that patent. So that's why this is something that becomes very, very important. Patents are territorial rights, as we discussed. They are applicable only in the country where you have applied for, and protection granted is for limited period. Generally we have seen that this is 20 years. So this is what patent is. Now, another aspect to understand from patents perspective is that we are talking about two things. We are talking about the product and we are also talking about the process. So there can be product patents and there can be process patents. Meaning what? If I have a new product in the market, then in that case it will be called as a product patent. And if I have a new way of manufacturing something, let's say, then in that case it will be called as what? A process patent. So for example, I already know how to manufacture a television, let's say. But I now have a new way that I've come across, a new way, a new technology to manufacture these televisions. Then in that case, this becomes a process patent. And if there is a new television that I have invented, a new product that I have introduced into the market, then in that case, that becomes a product patent. Now, if you look at India, if you talk about Indian Patents Act of 1970, then there India had only provided process patent there. But after the TRIPS agreement, we'll discuss about TRIPS agreement in the coming lectures. But after the TRIPS agreement, what happened is that India started providing product patent. So product patent, in a way you can say, supersedes process patent, because product, it's a new product altogether. So that's why it also always will be at a higher pedestal as compared to process patent. So that's why these are the two kinds of patents that we need to understand. Now let's move on to another kind of intellectual property, and this is copyright. Now, where is copyright applicable? Copyrights are applicable in artistic and literary work. For example, movies. For example, books. For example, music, a new song. All these things will be covered under copyrights. This lecture that you are watching, covered under copyrights and owned by the company that is Byju's. So this is where copyrights are involved. Now, when it comes to copyrights, again, copyrights are also provided by countries separately, but at the same time, you have to understand that copyrights are normally automatically applicable everywhere. So, for example, if I have published a book today, then it does not mean that this copyright for the book is only applicable in India, but under Berne Convention, just remember this, under Berne Convention, it can be made applicable in other countries as well. So it's not like patent where you have to go to each and every country and you have to go and apply for patents. Here, copyrights can become applicable automatically. So that's why, although countries do provide it, there is a legal system, there is a legal framework in India also, for example, and we are providing copyrights under that framework. But at the same time, it's not that something that has been produced in the USA can simply be copied in India. If it is simply copied in India, let's say even translated, then in that case, the original publisher can strike a copyright claim. And that's why, for example, if you talk about YouTube, on YouTube, if somebody has released a video, you cannot simply just copy that video, download that video, and also publish it from your channel. It won't be allowed. And if you do that, then in that case, the original owner of that video can also come back to you and they can do a copyright strike on your channel. So that's why the content that you create, the content that you have on your channel, that should either be an original work, or even if, let's say, it is not an original work, you first have to acquire the copyrights from the original owner, and then only you can publish it. Then only you would be allowed to publish it. So that's why copyrights will be applicable in all these kind of areas. Now let's think of a way in which a question even in the prelims examination can come from copyrights. Let's say the question gives you five options or four options: books, movies, computer programs, songs, or even, let's say, slogans. Let's say they have given you these five options, and then there are options that have been given, that which of the following can be covered under copyrights. So I think you are very sure that books, movies, songs will be there. Now, what about computer programs? What about slogans? Can they also be covered under copyrights? Actually, they can be. Even computer programs can be covered under copyrights. If I have written a new program, then in that case, I can get a copyright claim for that. But I cannot get, let's say there is a sixth option. Let's say there is a sixth option, and this is a mathematical process. Can I get a copyright for mathematical process, I cannot, because mathematical processes will be derived from the formula and these are originals. So that's why it will not come under copyrights. But programs, computer programs can come under copyrights. Slogans can come under copyrights. Although slogans many of the times may not be, but if somebody applies for copyrights, there are chances that somebody will be granted copyright for the slogans as well. So what all will be covered? Literary works such as novels, poems, plays, reference works, newspaper articles, etc. Computer programs, databases, films, musical compositions, choreography, artistic works such as paintings, drawings, photographs, and sculptures, architecture, advertisements, maps, technical drawings, etc. So all these kind of things can be covered under copyright. So just understand that how copyrights are applicable and what are the kinds of things where it is applicable. And that's why it will not be applicable to ideas, to procedures, to methods of operations or mathematical concepts. For all these kind of things, you cannot say that you can get a copyright. All right. Now comes another question, that what kind of rights are provided under copyrights. So one is for sure that we get economic benefits out of it. So one, there will be economic rights, that is my right to gain anything financially out of the copyright that I have. It allows me to get the benefits, financial benefits. It allows me to stop somebody from even republishing my work, even translating my work. Let's say I have published a book in English, then in that case somebody tomorrow can just go and translate that book in Hindi and also publish it, maybe with their own publication. Are they allowed to do that? They are not. They can't do it. Without my permission, that translation of that work also cannot be done. So that's why each and every aspect in this manner is covered under copyrights. Then the second is moral rights. That basically you can say in a manner something that protects my non-financial values. So for example, acknowledgement, that I am getting the acknowledgement out of the book that I have published. That also is a kind of a right. So this also is covered under copyright. So that's why there are economic rights and there are moral rights which are non-economic in nature. The next intellectual property rights are trademarks. So what are trademarks? A sign capable of distinguishing the goods or services of one enterprise from those of other enterprises. So it could be a text, it could be a number, it could be a special character, it could be a drawing, it could be a combination of one or two of these things. So just that in a manner I am trying to represent one enterprise. For example, the logo that you see on the top of your screen, the Byju's logo. This is something that is a trademark. That if you see this logo anywhere on any video or any book, it means that it does have something to do with Byju's. Correct? So this is how trademarks are used. That if you see a certain trademark, you see a certain logo, you see a certain drawing, and you recognize that this belongs to this company, this belongs to this enterprise. So that is the whole idea behind trademarks. Now, there are two things that you might have seen. One, TM, and one is R. These kind of things are often seen on the logos, etc. What is the meaning of these? When you see TM, TM simply means that we have applied for the trademark, but we have not yet gained it. We have not yet acquired it. It is still under process. But we don't want others to also start using it. So that's why we put TM there, that look, I have this picture in mind. This is a picture that I've applied for trademarks. I've not received a confirmation yet, but till that time, I don't want anyone else to use it. So that's why TM will be used. So it will not happen that, let's say I have the Byju's logo with TM today and somebody else also starts using the same tomorrow. Because even if they file for it, they have filed for it after us. There are huge possibilities that they'll not get it before us. So ultimately what will happen is that the first company to file for it will get it registered, and ultimately after they have registered it, then after that they can use this R. So this R stands for registered trademark. And this drawing or this logo now represents your brand, it represents your enterprise, your company. So this is how trademarks are used. So it can be understood as a sign, design, or expression that can be easily recognized and which identifies the products and services of a particular source and makes it unique from those of others. And trademarks which are used to identify services are also called as service marks. So there can be trademarks and there can be service marks. So service marks will become more exclusive in a manner that they are being used only for one service or the other. So in that case, for example, if you see, there will be different logos that will be used by a company, there will be little variations that will be used. So these are service marks. So this is how trademark works. The next one is industrial design right. Now, when we talk about industrial design right, this is something which is more to do with the aesthetic aspects of a product rather than the working of the product. So, when we look at the designs, so let's say, for example, if we take cars, there is a new car that is being developed by a company. Now, in this case, first of all, they might also think of how the car should look from outside, from inside. How do they want the front end of the car to look like? How do they want the back end of the car to look like? What kind of designs do they want for the seats, etc.? So each and everything has to be designed. So this design will become a part of industrial design, right? So it's nothing to do with the mechanics of the car, it's nothing to do with the functionalities of the car, but it is about how the car is going to look, the aesthetics of the car. So that's why these kind of things, which are not utilitarian in nature but rather more to do with the aesthetics of a product, will be under will be coming under industrial design rights. So it could be any product in the market, it could be a big industrial product, it could be a small household product as well. So each and every one of these things will come under industrial design rights. Now, industrial design rights can also be two-dimensional or they can be three-dimensional. Meaning what? When we talk about three-dimensional, it could be about the shape of the car, it could be about the size of the car or any product for that matter. And two-dimensional aspects would be the kinds of colors that will be used, the kinds of patterns that will be used. So all these will also come under industrial design rights. So this is how industrial design right has to be understood. Then after that we have trade secrets. So when we talk about trade secrets, these are intellectual property rights on confidential information which may be sold or licensed. There are many examples, and let me take some of the easier examples that are available in the market. Coca-Cola. For another example, Maggi Masala. Now what is unique here? There are many aerated drinks, correct? There are many cola drinks. You have Pepsi in the market, you have Thumbs Up in the market, you have Coca-Cola in the market. Now all these taste a bit different from one another. Why is that? Because there is a unique set of ingredients, a unique process that is being used for making all these colas. So ultimately what happens is that this becomes a trade secret for the company, because this taste has a value, this unique taste has a value, and the product is sold because of this unique taste that it has. Maggi masala. There are other noodles as well, and there are seasonings for all these noodles available. But all these seasonings are different from one another. Correct? They do not exactly taste the same. So in this case also, this is also something that comes under trade secrets. That only the people who are authorized to know how exactly the ingredients have to be used, what kind of ingredients have to be used in Maggi masala, they are the only ones who would come under trade secrets. The entire company, each and every employee will not come under trade secret. Only the people who are authorized to know it, only the people who know about this trade secret, who know about the exact composition, ingredients, process, etc., they are the ones who would be covered under trade secrets, so that the secret of the company does not become a public information, so as to ensure that people cannot simply just replicate the exact ingredient, the process, the composition, because this is something that holds a huge value for the company. So this is how trade secret has to be understood. So in general, to qualify as trade secret, the information must be commercially valuable for the company, should be known only to a limited group of persons. Anyway, because if everybody knows, you don't know how the secret will be leaked. So that's why there has to be a limited number of people who know about the trade secret, and be subject to reasonable steps taken by the rightful holder of the information to keep it secret, including the use of confidentiality agreements for business partners and employees. So anyone who knows the trade secret will be under the legal framework to protect that secret, and they cannot simply just sell that secret. And if they do that, there can be consequences, there can be punishments, offenses, there it will be a punishable offense. And that's why this is something that the company will always want to protect. And lastly, we have geographical indication. Now when we talk about geographical indication, what does it mean? Geographical indication meaning that when we are talking about any product or any service, this is something which is related to the geography of a given area. It has its unique properties, it has its unique value because it originates from that area, and that's why it is called as geographical indication. So for example, we have many, let's say even if you talk about India, there are more than 600 different kinds of geographical indications that are present in India. For example, basmati rice in many states it is being grown, but wherever it is being grown, it has geographical indication of that area. Nagpur oranges, it has uniqueness because it is originating from Nagpur, and the oranges from other parts of the country cannot use Nagpur in their oranges. Darjeeling tea, Kangra tea, all these have unique identification. So for example, Mysore sandalwood soap, it has a uniqueness because it originates from Mysore, and if sandalwood has been taken from any other area, the name Mysore cannot be used. So this is how geographical indication is represented, and it has its value because of that particular area. So that's why there are many such examples that we have. In India only, if we take, there are so many examples that are present. We can take Fulkari paintings, for example, of Punjab, Haryana and Rajasthan. So all these are examples of geographical indication. Why is it important? Because it has its uniqueness because of the geography of that area, because of the geography that is laden along with, because of the geography that is riding along with the name of that product. So that's why it becomes very essential for a product to have that indication so that it stands out apart from any other product of a similar variety. So that's why orange, but Nagpur orange would have some significance. Lychee in general, but royal lychee of Bihar will have its significance. So that's why these are called as geographical indication. So geographical indication is a sign used on products that have specific geographical origin and possess qualities or reputation that are due to that origin. Right? So that's why it carries a reputation, and that's why it becomes much more valuable as compared to the other products of the same variety. So some of the examples are basmati rice, Nagpur oranges, and as I said, there are many other. For example, I mentioned Mysore sandalwood, originating where? Karnataka. For example, something which is very famous, Lacha saffron or kesar, coming from where? Coming from Jammu and Kashmir. So there are many such examples that we have of geographical indication. Now with this we come to an end of the different kinds of IPRs that are provided. Now what we'll do next is we'll move on to a very important topic, and that is National IPR Policy of India 2016. So what was the need of that IPR policy? What do we achieve out of that IPR policy? What would be the advantages? What are the highlights? What are the objectives of the policy? All these are the things that we have to learn in the next segment.